Institute of Science and Technology's AI Special Interest Group online seminars, introduced by me, Richard Saldana. These seminars aim to explore a wide range of AI-related topics with invited experts. It gives me great pleasure to introduce 4 seasoned international legal professionals with more than a keen interest in AI developments to you today. Kiran Gore, based in Washington, D.C., is an independent arbitrator and counsel at her own law offices. In addition, Kiran is a professorial lecturer in law at the George Washington University Law School. She is an arbitrator, dispute resolution consultant, and counsel with 15 years of experience in public and private international law, international development, foreign investment strategies, and legal investigation. Dr. Mika Lehtimäki from Hämeenlinna, Finland, is a lawyer and founder of Bayesian Realm, a company that builds predictive AI models for complex financial and legal systems. Mika's work encompasses AI engineering and algorithmic game theory. He is involved in structuring and negotiating corporate and financial transactions, has extensive experience of Finnish law and common law, and his expertise means that he often works with institutions active in investment management. Bhagyashree Pancholy, joining us today from Udaipur in India, is a lawyer and AI startup founder with over 12 years technology law experience, specializing in privacy generally and biometrics privacy in particular, as well as intellectual property. She has served as the product counsel for AI companies for many years and has worked in the EU, Asia, Asia Pacific, and North American regions. Bhagyashree has been a founder of 2 AI startups in Switzerland. The first made self-learning AI chatbots, and the second provided AI and algorithmic auditing services. Dr. Rupert Macy-Dare from Oxford, UK, is a commercial barrister at Minerva Chambers and former solicitor advocate from Freshfields. He holds a doctorate in economics and finance from the University of Oxford and a diploma in computer science from the University of Cambridge. His interests include the future of work, the business and practice of law, legal, economic, and computational thinking, AI, the path to artificial general intelligence, and uses of AI in law. Welcome to our panelists, a truly international group from 4 locations around the globe. Let's get straight into it. What does AI generally mean to you as a lawyer? Mika.
Thanks, Richard. Well, I must say, it has had a profound effect on my work. I used to be a corporate attorney for more than 20 years, doing corporate financial transactions, switched to game theory and coding a few years back. So I've transferred to 100% of my time drafting contracts and negotiating, to 100% of my time coding systems, replicating what lawyers do, creating systems that kind of do what the lawyers have been doing for a long time. So I think that for me personally, there's a fundamental regime change taking place, changing the way we work and changing the way we understand the law.
Thank you. Bhagyashree.
Well, I would actually go back to the first definition that, John McCarthy, whatever he coined AI as, was a clever way of engineering and developing machines. And to me, that pretty much resonates because, the entire concept of artificial general intelligence and AI becoming smarter than humans pretty much defeats what it was initially started to be known as. Do I think that AI would replace humans? We're going to come to it next. But right now, for me, AI is just a clever way of doing things with the help of smarter machines. That's it.
Okay, so thinking machines. I think I sort of share that opinion. I have a healthy skepticism of AI myself. Rupert.
I would say that artificial intelligence encompasses expert systems, non-human expert systems that seem to exhibit thinking type processes and output.
Okay. Kiran.
Thank you, Richard. I'll pull on Bhagyashree's and Rupert's thoughts to say that it really represents an opportunity for law and lawyers, courts, etc., because it has the potential, AI provides the potential for us to transform the way that we do legal work. And there's quite a lot of thought leadership out there and has been for a long time, including from Richard Susskind, that suggests that lawyers, for the past 100 years have done things in the exact same way. without rethinking the way that they do work. And I think because of AI, we're in a position to rethink the way that we do our work, and that, you know, maybe jumping ahead a little bit to the future of work, I think it will change how our future lawyers process information, what their job roles may be. So although I share, Richard, and hear you very loud and clear, there's the skepticism as to whether it's really transforming what we're doing today. I think there's a lot of great opportunity to transform the practice of law or the teaching of law more generally going into the future.
Excellent. So picking up on that, Kiran, I'm going to stick with you for the moment. Where do you see law and AI in, say, 5 years' time?
Great question. 5 years sounds far away, but it's actually quite soon. I think it might be too soon to be transformative. I think where we are right now, at least I say this as a legal professor, so as an educator of law working with current students, and I say this as a practitioner in courts and arbitral tribunals with an international focus. So, you know, you have various approaches being adopted for both AI and use of AI in legal practice around the world. So sort of using those frameworks, I would say that we probably won't be anywhere different than we are today, except that those lawyers or those law students who have learned how to use AI well and understand it well will be better poised for future opportunities that we cannot imagine exist today. So if we think about the transformation of legal practice, those lawyers who have kind of put in the work to learn and understand, who, you know, it's not very different from where we might have been when I was a junior lawyer more than 10 years ago, where those lawyers who were really adept at, you know, using machine learning and other tools in relation to document review or e-discovery, those became the lawyers who adopted leadership positions and teams about evidence and evidentiary hearings because they could manage large amounts of information better and faster than others. Although in those days, it was a really minimized skill set. I mean, if you were good at document review, nobody thought very highly of you or regarded you very well, but secretly you were becoming a really good lawyer. And I think it's similarly with you know, more modern AI uses. You know, machine learning is a predecessor in many ways to what we're talking about today. And I guess I'm thinking more of Gen AI at the moment as I'm answering your question. But so at the moment, I think probably no impact in 5 years, but those lawyers who have spent those 5 years learning about it and understanding how it could be useful are going to be better positioned than others.
Thank you. Bhagyashree, what do you think? You've been involved in a number of startups.
I agree with what Kiran says. In my opinion, it's just going to aid the lawyers. It's not definitely going to replace the lawyers. There's going to be a whole lot of components and segments that are going to come into basic preparation for a case or contract negotiation or drafting. But definitely, we don't see AI litigating anytime soon. We are not going to see AI being pleading in front of judges in courtrooms anytime soon. There is definitely going to be a big revolution. We've already started seeing with the generative AI tools in contract and corporate governance, but anything more than that, we are yet to see, because we also have challenges when it comes to privacy and intellectual property. So when we talk about where it would be in 5 years, we have to look at both the sides, how IP and privacy is going to actually put the brakes on the AI joyride in law. We are yet to see, but yes, there would be some braking effort definitely there.
Okay, thank you. Rupert, I know you have some quite strong views on this subject, and if you want to gaze a little further into the future, I'm happy for you to do so.
Okay, you're tempting me outside off stump here. I mean, I think if you look, say, 10 years ahead, I take a more extreme view. I think that the practice of professional law will be completely transformed and unrecognizable from where it is today. I think it'll be a much smaller technology business. Now, if you look 5 years ahead, you know, halfway there, whether we'll have gone through the transition point, you know, I imagine there'll be some kind of collapse type model. So it goes on business as usual. Suddenly the number of new recruits and trainees plummets to almost zero. It could well have happened in 5 years. I think things are moving much faster than most people are really tuned into.
Mika, would you care to comment?
Yes, I think Rupert's right with that, with his comment. I think we're going to see widespread use on all levels of AI. And there's one thing that we haven't touched upon yet, which is a competitive requirement. Big law firms are seeing it has a strong competitive edge, and we're going to be seeing a lot of investments on that area. Now, connected to that, I think that there's a extremely good positive development concerning these matters, which is access to justice. This is a rule of law perspective. I think we're going to be seeing systems that provide people, especially regular people and smaller businesses, with better access to sufficiently good legal advice on a level that we haven't seen before, on almost on a real-time basis. So I think that's a good development, and we'll be seeing that occurring within the next few years.
That's a really interesting point. So, I mean, in terms of what I'm hearing is there is likely to be a lot of job displacement in terms of the legal profession. I mean, isn't that quite hazardous to new people, new students coming into the law today? Rupert, would you care to comment?
Well, I mean, what I'd say is, I remember, and I'm sure you do, Richard, those people trading on life, the pit traders in their stripy jackets. It seemed they'd go on forever. Suddenly, they were all displaced by technology. So I think, unfortunately, this is likely to happen. Luckily, lawyers are very versatile. They'll find other stuff to do, but it won't necessarily be as professional lawyers in the old format. Okay.
Kiran, you're an educator. Would you care to comment on this? This must be an area close to your heart.
It is. It's actually a hot topic because you're already seeing some students who are embracing it, and you're seeing those who are worried and afraid of it, that they feel like they will be displaced. And what's the point of becoming a junior lawyer if a machine would do your job or what was thought to be your job? At the same time, in legal education, there's a lot of thoughts, and I've attended a few panels recently at the American Bar Association's International Law Conference where they focus on this about, well, what integrity, plagiarism, academic criteria and standards. So forget about the practice of law, but the actual legal education. I mean, for God's sakes, I teach legal research and writing to international lawyers at the GW Law School. And that's hard to teach when your students are interested in using generative AI technologies to help them with both their research and writing. So I think it puts educators in a very unique position. Number one, we should, I think, not resist, but embrace some of those tools to the degree that academic integrity allows us to. So the student should learn how to perform certain skills or understand certain skills so that they can work with, very smart computers, as the other panelists have said, to do their job better. But it's sort of like a smell test. You know it when you see it. You know good legal writing when you see it, but you couldn't know that until you've seen how it gets done or learned how to perform it. So I think that's the tension for where the future is going, that lawyers who learn how to perform good skills and then work with machines to improve those skills, perhaps get there faster or better or improve their work, so on and so forth, will achieve greater results in the longer term. On the other hand, some of us could get stuck spinning our wheels. At the same time, I think there's a democratizing feature, and Mika already touched upon this. And there's actually an emerging debate on this. Some say that bigger firms, global law firms like the Freshfields of the world, will get there faster because they have greater resources and they can, build their own models, Harvey AI, they can throw all these resources into it. While the other side is saying, well, solo practitioners, people like me, might get there faster because we can innovate, we can try new things, we're not constrained by the big corporate machine. I actually don't know. I think it's really interesting because I think people saying that larger firms will get there faster, that they will embrace the use faster and train their lawyers better is a newer strain of thought. I hadn't heard that until maybe a week or two ago. Before that, it was really seen as a way to democratize not just access to justice from lay people, non-lawyers, but also lawyers who operate with less quote unquote resources. I think it's an interesting thing to see because I think it will change the practice of law for sure. Create new jobs. You might, become the person who develops pumps as opposed to the person who who dug through documents, for example. I think if you learn how to use technology well, it can be great. Personally, I've worked at a global law firm where I was that person who tried to do interesting technology related things because we had subscriptions and access to these great tools. And I always got a lot of pushback where people are like, why are you telling me to log into the system I've never heard of? And I was like, well, it's right there on your desktop. We all have access to it. I actually just clicked on it. And it was so cool. It makes a chronology and organizes your documents. It's amazing. And they were like, yeah, no, we want a Word document. Create a chart in a Word document and then print out the Word document for me. And I'll mark it up by hand, right? So there's quite a lot of tension. I don't know who will get there faster, but for sure, those who are using technology better or know how to use it better have greater longevity, I think, in their practice longer term.
Thank you. Let's move on. Are we concerned about privacy and AI? Bhagyashree, this is a particular area of expertise for you.
Well, we aren't, to be very honest, because we were chatting and most of us do use ChatGPT. Now, if we were super concerned about privacy, we wouldn't be using any of these generative AI tools. We won't be even here because if you read the notification at the beginning of this recording session, it pretty much did notify us that what we are saying is recorded and it would be used for some regeneration by an AI. So a lot of people have definitely, they're trying to strike a balance between the comfort and the use of technology to automate and speeden up their work, and between privacy. And what we are seeing, unfortunately, privacy is taking a backseat. Now, the concern with privacy is when we talk about privacy, a lot of people are like, yeah, fine, if somebody's going to snoop on us and see where we go shopping or what kind of groceries we are buying, that's fine. And I agree, that's fine, because that's not confidential or highly sensitive information. But the problem begins when they start tracking your biometrics, or they start tracking children privacy. It's a big problem now. And this is where people are, I think it all comes down to being aware of your rights and the consequences of allowing any artificial intelligence tool to scrape your data and train or fine-tune their existing database, and the ease of doing projects. So yes, definitely a lot of people are not paying attention to privacy. Even if you were to look at the lawsuits that have been going on across the world, a lot of them are focusing on copyright infringements and intellectual property. We haven't been seeing a lot on privacy, and there's a reason to it, because you do not have enough evidence to prove that your privacy was compromised in any sense. And that pretty much speaks volumes about how sensitive or what camouflage is going on behind these tools.
Mika, you're developing intelligent software. What's your view?
That is correct. I think that's something that strikes me as the most important thing, probably. The whole thing is so-called closed systems and open source systems. And I think that we should be seeing plenty of discussions where lawyers participate in this debate. And I think that's one of the one of the most crucial issues that we'll have to face within the next few years, even already now, whether we support closed systems or open systems. And I think that I'm not sure who mentioned big law firms' use of their own data and documentation and all, but they do have an edge. And there's also a risk with those kind of situations. Yes, so I think that's the key here, and something that I'm kind of worried about.
Okay. Rupert, do you have a comment on privacy and AI?
Well, I mean, just a general comment that I see a sort of dangerous nexus if you've got lack of privacy controls, AI systems really flourishing, and a surveillance society. I think that could be a very bad outcome.
Is that a LexisNexis? Sorry, I couldn't resist. Kiran, any final comments on sort of the sort of privacy in AI?
Nothing different from what the prior panelists had said, except I would add that, read the use terms for everything that you download or try out, because you would be shocked at some of the things that you sign away. And I would just also encourage, and this is not just for lawyers, of course, this is for everyone, I'd encourage you to look at the default settings of various tools that you download as well, because you would be shocked what they use for training purposes, and you might not be pleased with that. And so this goes to various other issues, but just keep an eye on it, is what I would say.
I mean, does anyone read the small print on the app that is installed on your phone?
Probably not, right? That's I think the key issue, that or even the cookies, right? Who pays attention to cookies? Just hit accept all as fast as you can just to move on with your life.
Absolutely. I think it's a good point to sort of move on to ethics. What do you think are the main ethical considerations surrounding AI-powered legal research and decision-making tools, perhaps for judges? Rupert, let's start with you.
Good point. There's a corpus of judicial ethics. There are ethics concerned with privacy. I suppose the key is that one wants to sort of perpetuate and build on the ethical framework that currently exists, rather than sort of go off into new unethical territory. That'd be my thought.
Okay, Kiran, anything to add here?
I mean, there's great potential longer term, and you already are seeing that some courts and judges are using artificial intelligence powered systems. So there have already been robo judges that have been unveiled in some jurisdictions. There's also been at least one English judge who has said that he's used generative AI to draft portions of judgment that was issued. In Colombia, it was the same thing. And I believe Bhagyashree might be able to correct me, but I believe it was India where they've unveiled some sort of robo judges. It's an interesting proposal and opportunity, because if you actually think back to the development of law and courts and legal systems, kind of going to the eBay customer dispute resolution model, which is sort of the origins of many of the things we're talking about in the 1990s, that was revolutionary, and it's been the foundation for a lot of what we are now continuing to build out into the public sector for access to justice today. And the eBay customer dispute resolution system, where you could build trust in the system, worked very, very well. So how far can you take that by unveiling something like that broader and for a public good, a public service? You have online courts, you can have predictive decision making. I think we're not quite there, because you need to build the trust. But I think you'd be shocked at how quickly that trust can be built if there's transparency and accountability. And so maybe this goes to broader things about data sets and broader education beyond the legal profession on these topics.
Thank you. Bhagyashree, you care to comment? Tell us more about those robo judges in India.
Well, they aren't only here. They've been unveiled in many other jurisdictions, and there are also courts that are actively using generative AI tools or AI tools to research for judgments and pronounce judgments and write judgments. We also recently had a case where, I think it was in Brazil, one of the communities drafted water bills with ChatGPT, and it was passed by the city council. So now it became a law. So it's no longer legal research, but then there are laws being drafted with the help of ChatGPT. But I do want to address a different point here, and it stems from my understanding at my previous startup, where we were doing auditing and algorithmic assessments. And this is an important distinction that I want to address. We talk about bias and we talk about fairness. We should actually be talking about fairness, because bias is sometimes necessary in the training data sets because it acts as a yardstick against which you have to measure what not to do. So bias in the training data sets is not always a bad thing. So everyone needs to understand this distinction, that bias is not always bad. Sometimes you also require bias. And we did one audit for, I'm not going to name, but what do you call them? I think a beauty company that has a lot of retail stores across the globe. And we had to have the bias of, let's say, brown skin color in the data sets because there were certain shades of makeup that would go with the brown shade. Now, if we were to talk about it and somebody would say, hey, why are you talking about brown, black, and white here? And of course, it's not a language, not the terms that we want to be using, but for the lack of proper terms to be used, we were using it for a particular use. So we need to connect bias to the usage or the intention or the intended use. And coming back to ethical considerations, definitely fairness in tools that are being used by judges or in law has to be the primary consideration. But come to think of it, we are all lawyers and we've seen that judges are not necessarily bias-free. So what do we expect from machines? When humans have bias, and it's our bias that infiltrates the data sets. So yeah, but fairness is definitely a consideration.
Bhagyashree, I fully understand what you're talking about. You're talking about bias in different contexts. I understand it from a statistical point of view, the bias variance trade-off, etc. And I might bias actually my data set if I have rarity, for example, and that is important to sort of bring out. So I understand appropriate uses of bias. But Mika, any comments on ethics?
Absolutely. I have a two kind of stage solution. It's really a practical one, since I'm writing these things every single day. And I think that the systems are extremely sensitive to how you structure the prompts and use the agent and the tools in the system on top of the large language model, for example. You write these things down. And I think that as long as you use it for legal purposes, there should be full transparency how the system is instructed to work. It's just a half a page, maybe 2 pages of text, usually. For legal purpose, you should have full transparency if you want to use that for a basis of a legal judgment. Second point, I think that we should only use systems on large language models that produce ethical statements connected to their models. So for example, Meta, which is a parent company of Facebook, that has a really wonderful open source models, produces these as do some of the other open source companies as well. And we should not allow anything to be used for legal analysis unless these ethical statements and these papers that they produce are produced for that purpose. So only use those kind of systems that have backing and the ethical kind of fine-tuning rules, and which are transparent and told out loud to the people who use them. So that's why I think it's really a practical thing. It's about transparency, fully about transparency.
Okay, thank you. That moves us nicely on to sort of regulation and responsibility. So what frameworks need to be developed, do you think, to ensure responsible development and deployment of AI in illegal applications specifically? Let's start with Kiran.
So that's a big topic, Richard. Let me take a small piece of it where I think I'm probably best placed, which is use by practicing lawyers before courts and tribunals. So what you're already seeing is there are a couple of different tranches. One is unregulated use. The other is use but disclosure of such use. And the final bucket that I'll throw out there is you can use it. You don't have to disclose that you used it, but you do need to affirm that if it was used, a human has checked that work. So each of those 3 models takes a very different approach. Frankly, I prefer the last bucket, which is you can use it, you don't have to disclose what you did with it, but a human needs to have checked it, because that is the version of regulation and disclosure, at least for lawyers appearing before courts and tribunals, that most broadly matches what lawyers are supposed to be doing anyway. So if you imagine, you know, a barrister who appears before a court has an entire team behind him or her, who, you know, including paralegals, junior lawyers, law clerks, etc. They should always be checking that work, ensuring that the evidence says what they claim it says, that the law is what they claim it is, that there's no hope. The law actually exists, right? It has not been made up or hallucinated by some kind of chatbot. So if you think about regulation and disclosure, that is what lawyers should be doing anyway. That is our duty, as when we appear in the US, lawyers are officers of the court. So when you appear before a court, that is your duty to have done that. And there are a few instances in the US. In particular, there's a federal judge in Texas, in the Southern District of Texas, who has a new standing order that he unrolled, I think it was at the beginning of this year, which for every new matter filed in before him on his docket, the lawyers must file an affirmation saying, if I use generative AI or chatbots, et cetera, anything like ChatGPT, that a human, you know, a lawyer who's appearing in this matter will check it. That, I think, makes most sense to me because it matches with pre-existing obligations. Now, where I struggle is disclosure, kind of explaining how the sausage has been made, right? So it's nobody's business how a lawyer does their work. If I have minions who help me with my work, if I don't have minions who help me with my work, if I use computers, if I don't use computers, it's kind of nobody's business, right? Especially not my opposing counsel. So I hesitate to say that because I've used really smart computers that I need to explain that I use those very smart computers and what those very smart computers help me to do, because that invades the personal space of a lawyer's, you know, legal strategy and approach. At the same time, I also think the first bucket I had mentioned, completely unregulated, no disclosure, kind of do what you want. I think that's very dangerous, right? Because there does need to be guardrails and accountability. So I've presented 3 models, at least for appearing before courts and tribunals, where there is a sort of a forum where that kind of disclosure would be needed. Now, what's the challenge is international legal practice, which is where my space is, because different jurisdictions are taking different approaches. It's kind of like what we already have had for years and years about ethics and conflicts of interest and things like that for lawyers, that different jurisdictions have different views on ethical requirements, ethical guidelines, et cetera, confidentiality, attorney-client privilege. This is just another one of those topics, and I would approach it in the same way. The hardest time that lawyers will have are those who are admitted in multiple jurisdictions, where you might have conflicting. So typically, you know, if in this jurisdiction you're admitted, you have this requirement, in this one you're admitted, you have a higher requirement. You as a human are expected to adhere to the highest requirement that applies to you as a lawyer admitted in multiple jurisdictions, so that you're not, you know, flouting anything that applies to you. But that's something to think about. But I would say that think about this in the same metrics as you think of other ethical confidentiality, attorney-client privilege types of boundaries. Okay,
thank you. No, that's very, very comprehensive, I thought. Rupert, I heard Kiran mention the word barrister.
Yeah, well,
yeah.
I think she was talking generically there, but just to say, I mean, I think that, you know, both clients and courts actually want to look a bit further behind the veil. You know, typically with a client for commercial cases, they'll want detailed breakdowns. In fact, in the UK, it's often by every 6 minutes, knowing exactly who did what. And that would be for every individual lawyer, class of lawyer, types of system used. In the adversarial system we have here, it's usually the case that if you win, the other side pay your costs, but only if the costs are reasonable. So then you have to produce a detailed schedule of what those costs are. And in fact, there are sort of cost offers and a bit of gameplay about whether or not to settle. And once again, you have to give details, really exacting details of what the costs were. So I think this will actually all come out in the wash.
Okay. Bhagyashree, so guardrails, regulation, what's required?
Well, I really do not think that there needs to be a specific category for, legal. I think pretty much the existing ones serve us better. However, I'm not very comfortable with how they've regulated the entire development of AI under risk and use, because use is very subjective. Then, when you do use, then you have to look into the use of every person that's using, every industry that's using. The intention behind such a use. It gets pretty complicated, and it sounds more market friendly, but it is very, very complicated when it comes to regulations. In the legal framework, pretty much I do agree with what Kiran said, that if anything else that needs to be added specifically for the legal industry is just a disclosure that whatever's being produced in the court was drafted or was researched with the help of a certain AI technology, so that people know that this cannot be 100% relied upon, until unless there's an affidavit filed saying that whatever is written is true and the best of the knowledge. And now we use the term in a lot of common law jurisdictions as best of knowledge. So my knowledge, even though I'm promising to the court that it's best of the knowledge, it may not be. So, you can't really, so there's a lot of wordplay, there's a lot of procedural lacunas in our, in the way we conduct ourselves in the courts. But as far as any additional categories concerned, I do not think that legal requires any special category. Pretty much well covered under the existing laws.
Okay, an interesting view. Mika, how would you like to be regulated? You're at the cutting edge of a lot of this.
I know. First of all, we should not regulate mathematics. We shouldn't regulate mathematics. We shouldn't regulate the system as such, the model. We can't do that, in my opinion. We should concentrate on the factors that were mentioned previously, which is disclosure, transparency. I think that's the way. And in addition to that, the usual duty of care of a professional counsel. I think that's the correct way. But I've heard some, well, not optimal ways of regulating artificial intelligence systems, and I think that we should avoid regulating mathematics and models as such. So concentrate on transparency, disclosure, and potential breach of duty of care of these people. For example, we use game theory as well, which is a highly kind of mathematical, strategic way of thinking. And that's just mathematics and economics. And I don't think we should have restrictions on using those kind of things, just as long as it's transparent and people who are using that are going along with their obligations as usual.
Well, I rather agree with that as sort of a mathematician, statistician myself. Mathematics is in some way truth. I mean, I like to believe that. It's more the sort of irresponsible or nefarious sort of development of AI systems that I really want to sort of touch on here. Is it possible to sort of guard against that sort of insidious use of such systems?
Absolutely, it is possible, and we're going to be seeing a lot of dangerous developments from certain countries, for example, and governments concerning the use of AI. We'll be seeing a lot of regulating is actually that is the best way. That is the Western way of dealing with these kind of things. But we should have. It's going to be a tricky one internationally. These things are not contained in one single country. They flow throughout the globe pretty easily.
Yeah, I mean, regulation in the UK is not going to help us with a bad actor abroad. So anyway, we'll move on to some extent. If we do,
Rupert,
yes,
can I just cut in and just remind you, the European Union AI Act is going to be sweeping across the continent, and I think there will be a strong regulatory framework everywhere following that. Of course, these things are not perfect, but I think there will be some sort of straitjacket, of course, probably with carve-outs for defense and that kind of thing.
Yes, I am familiar with that, and we have actually discussed that amongst ourselves. Related, but just moving on a little bit. Assuming that we have AI systems that are making any sort of decision, who should be held accountable for those decisions? Let's start with you, Rupert.
I mean, well, there's a question: who do you hold responsible as the man in the street, and who does the law say? The law, perhaps augmented by AI, say is responsible. I mean, this is a question for legislators. You know, it may be the users, it may be the writers. They'll find some mix. I'm not sure it's fully resolved yet.
Okay. Shall we move on to education and learning? I think this is a very important topic. Kiran, as an educator, what do you think the outlook is for legal students, professionals, and consumers over the next few years in the context of AI?
I think it's a new skill set for sure that needs to be incorporated into legal education. Quite frankly, and I've only ever personally taught or attended law school in the US. So different jurisdictions will vary. But in the US, we have never, and you hear this all the time from lawyers from all sorts of law schools, they never learn actual practical skills and applications. They don't learn how to do, they learn how to think. And I think for this particular application, we need to learn how to do. And there are some really innovative incubators that are popping up at various law schools where they are working with students, including legal students, in looking at data sets, trying prompts, thinking about data-related biases, how do our systems work? And I think if we were to critically learn how to analyze these tools during our educations and learn how to play with them, how to practice with them, I think this is where we could learn a lot from some of the practical science and engineering disciplines about what our students should be doing, because there's great need and potential to have those skill sets. This comes up all the time with my students, and something I tell them, some of my students are older, they're not on their first law degree, they might have come from abroad and they're continuing their education because they wish to practice or live here in the US. And something I tell them all the time is that if your education is more recent, if you've just graduated from law school, even if it's as an LLM who has prior practice experience, your bosses will presume that you know how to do things they don't know how to do. They will presume that you know how to interact with data sets or use certain AI-based tools or prepare Gen AI prompts and interact with chatbots in a way that they don't know how to. So it's actually your obligation to have some of those skill sets because the market expects you to have them. So I think for students at the moment, they must. And I think for legal educators, we've got to find ways to incorporate that. So at least at GW Law School, we have choices in interacting with our integrity and plagiarism code of conduct. We have choices that we can implement into different courses. So I have, to the degree possible in my courses, chosen more liberal policies where students can brainstorm with Gen AI or with AI tools. They can't use them for writing purposes, but they can use them for brainstorming, for outlining. Something they'd normally hash out with a mentor or with me, they can hash it out with a chatbot. Or they can use it to create images and graphics for presentations that they might do. So they can't use it to write their paper, their research paper, but if they can use it to help guide them in doing that writing. And I think that's a really important skill set for students to play with. And I'll just share one quick story, because I'm not your AI friendly lawyer in many ways. I'm just a litigator, an international litigator. The way I became interested in Gen AI was a little over a year ago, where one of my students wrote me an email apologizing and requesting to withdraw from a presentation he was supposed to do that day. And he expressed a great level of remorse. And it was a very empathetic email that he explained why he couldn't do it. And I read the email. I was actually walking over to class from my office while reading this email, and I was on the street and I was like, okay, you can't do it. And then he had a PS that says, PS, this email was prepared by ChatGPT, but I agree with everything it says. So I'm walking down the street reading this email, and it was really filled with emotion and And I felt bad for him. And I was like, oh my God, he didn't even write the email. I've got to pay attention to what my students are doing. So for me, that was a moment, like a big aha moment where I was like, okay, we've got to work with students. I mean, it was a perfectly legitimate and appropriate use. And he disclosed, he was so great about it. But for me, it was like, okay, what do I do with my students and these tools that they now have available to them, especially my international students, where they might gain greater confidence from sounding things out or having an AI-based, Grammarly type tool. Grammarly also has AI-powered capabilities that helps them present their best work. And then that gets really interesting, right? How do you use these tools to present your best work? You've got the potential, but how do you get there better and faster? So that's just sort of my view on this.
At least your student was honest.
It was perfectly well executed. It was like the model ethically sound lawyer's approach, but man, he was lazy. He didn't do the presentation and he didn't write the email.
Absolutely. I'm going to bring Rupert in here because you have taught students and you continue to interact with young lawyers. Any comments here?
Yeah, I mean, I suppose I've got a slightly different view. I think if you think of academic law as taught in UK universities, there's huge demand. I actually see that collapsing and really becoming something like, the demand for undergraduate philosophy or theology or classics. So it'll be an enthusiast-only subject, but not with a career path that stretches out in front. I think there will be, conversely, I think legal technology will grow, could be absorbed into the business school or something. It'll be a different approach. Anyway, that's the kind of path I see.
Okay. Bhagyashree, I noticed that you're nodding away there. What would you care to add?
Well, I wish I was studying reading law now, because it would have made more sense not to read torts or jurisprudence or legal philosophy or school of thought. Absolutely never used any single day in my life. But I do agree with what Kiran is saying. We will soon see legal tech, and we don't talk about legal tech as an independent segment of what lawyers can get into, or legal operations. And both of these are very emerging, upcoming fields. All the law firms, the biggest ones, have pretty decent sized teams that are involved in legal ops and legal tech. If you remember our parents' generation, they used to write special skills, can draft emails. Now nobody writes, oh, I can WhatsApp or I can draft emails. It's going to be the same. Nobody's going to say, I can do research on generative AI tools or deploy AI. It's going to be something that we would learn. My daughter's already learned it. So, it's something that we will encompass in our daily lives, and it would be generally understood that everybody knows it. So I think it's going to be pretty usual now in few years down the line.
Okay, thank you. Mika, anything to add here? Outlook for legal students, but learning for all in the context of sort of AI and law professionals and consumers alike.
I think it's going to be happy times for law students. I think you get rid of these really tedious jobs, and especially for interns in law firms, and it's just kind of maybe if they got their job still, they can concentrate on something meaningful instead of something. We all been there, done these tedious thingies. So I think it's going to be wonderful.
Okay, that's great. I mean, a very, very refreshing feedback. Now, I think what I'd like to do now is sort of open this up to the audience. And I've noted here a very nice question from Robin Noble, who's at Oxera and in Oxford. And I wondered, Robin, if you wanted to unmute and perhaps pose your question yourself.
I'm an economist, and I'm very focused on the transformational effects that AI can have in these kinds of situations. I was particularly interested in some of the discussion about the fact that it may destroy lots of jobs. And I guess I was just looking back at some of the history of technology in law and economics and accounting, in that a lot of the technologies like spreadsheets and LexisNexis and case searches and so on, that one effect has been to make existing work faster, but it has often resulted in more case references, more analysis of data, rather than fewer accountants or fewer lawyers. And it'd be really useful just to hear from the panelists about what do they think is so different about Gen AI? Because there's certainly when there's examples we talked about earlier on about Freshfields and other big law firms using some of these technologies, I can see how at least one effect of that could be a bit like the case searches. You just have better document review. You have more examples to put to witnesses than you would otherwise. That doesn't obviously destroy work. That potentially just creates more work, or it's an arms race on both sides. So yes, it'd be really interesting to debate that with the panel.
So who'd like to comment?
Maybe I'll start and say, I've read this headline a lot, and I actually agree with it. I don't think it would destroy work so much as it would destroy the billing models that traditional legal practice is built upon. So the billable hour, as Rupert was describing, or rather the billable 6-minute increments, which, I still have clients that prefer I bill my time to them in 6-minute increments, and I resist that. I prefer alternative fee arrangements in many respects, but because the billable hour makes very little sense. It does not incentivize us as lawyers to do the best work in the most productive and effective way. It does not benefit our clients because it makes them spend more money in many respects. And if we talk about a world where AI-related tools can help us do things better, more creatively, and possibly faster, there's no place in that world for the billable hour or the billable 6-minute increments. I think there's definitely a lot of discussion out there as to, well, who bears the cost? If we're in a world where our clients presume that lawyers are using AI-driven tools to drive efficiencies, who pays for lawyers to have those tools, right? So even if you are a Freshfields and you have your own in-house Harvey AI type tool available to you to go through your own data, who bears that cost? Is it Freshfields, the firm, for having implemented across, or can they pass on a technology fee to their clients? And is it ethical to pass on that technology fee? And does it make up for the loss of the value of the billable hour? I don't know. I don't know the answers to that. But the few things are that it changes not the lawyers or their jobs, but it changes the model in which that lawyers are paid. And it should change the way lawyers are paid. But at the same time, it's not a cost-free proposition. And somebody does need to bear that cost, especially if it's being done in a responsible way, where you are ensuring that you're building systems that take into account GDPR, cybersecurity, data privacy, confidentiality, attorney-client privilege. If you're building really good systems and you're not just, going on the internet, finding a chatbot to talk to and tossing your privileged documents into it to have it summarize your documents for you, that's a problem, right? So the responsibility comes with costs because you're developing coherent and sound and safe systems. Of course, your clients also want you to keep those thoughts in mind. So I think there's efficiencies. Those efficiencies change the way that we do things. And at the same time, it adds costs that somebody needs to bear or at least be thinking proactively about. I also think it makes global law firms' offices of general counsel busier, because typically they only used to hear from the billing lawyers about, attorney-client privilege challenges or conflicts. But there are new concerns out there, and your clients might have in-house AI or other technology or data privacy or GDPR requirements. How do you take those requirements into account?
Comments from the rest of the panel?
Yeah, Richard, can I cut in here? I mean, if I would say that, if you look at current big law, about half the revenue that comes in will go out in costs for junior lawyers. So if you replace all those junior lawyers, you've saved half those costs. That surplus can be distributed, back to the clients or to the partners. They all have the incentives to try and get their share. I looked up the latest legal AI tools, and I found a sheet produced probably by an AI system, and it says benefits of AI tools for lawyers, 24/7 availability. Our AI assistant doesn't punch out at 5 p.m. It's there whenever you need it, working around the clock. Next bit, cost efficiency. Imagine a helping hand that doesn't demand a paycheck. So I think that the very big elephant in the room throughout our whole conversation is economics. Ultimately, the marginal cost of producing really good advice from an AI system is going to be 0 pence. The data on which it feeds, law cases, judgment statutes, are basically freely available. There are a lot of interested parties. So, I think it's going to have a natural momentum. And Robin, picking up what you're saying, I mean, I see this, the sort of analogies I see are, say, think of the long-standing craft of the shoemaker. For 1,000 years, you're getting bespoke handmade shoes. Richard tells me the last such shoemaker disappeared from Oxford recently. There is still some demand for this, but it's very limited. Technology changed. Now it's all done by factories, by computers. And in fact, the average number of shoes in Britain, I discovered, is something like 20 pairs each. There's much more consumption. So there'll probably be much more consumption of really good law. It just won't be produced by the same production technology of sort of handcrafting by individual human lawyers.
Can I present a different view here? And this is my first-hand experience. I was privy to one of the tools that we've been talking about, and I did use them for contract negotiation or review. And oh my God, the nightmare. I had more red lines than black and blue lines. And at one point, the team was like, chuck this. We're going to do the review on our own. We're not going to rely on any tool. Now, here we need to carve out the distinction between whether we are talking about AI, the artificial intelligence, or the generative AI, because generative AI is a different subset that we need to focus on. I'm not talking about AI, I'm talking about these Gen AI tools that Kiran just mentioned. And I'm afraid I do have to agree with Robin that perhaps we are thinking we are expecting too much too soon from this technology. It's it's in a nascent stage. Perhaps it would generate more work than it's going to automate for us. That's true. We are also seeing these laws and acts coming up. Now, we discussed in the afternoon how the AI Act is at crossroads with, let's say, GDPR. That requires a good amount of litigation if it goes into judicial interpretation. So we definitely, as lawyers, going to have more work. There's going to be an element of automation or the ease of doing certain things, but definitely we cannot be saying for sure that our work is going to be easier or, task management is going to be simpler. Like I said, we may just have a very bad red line version of a contract that would give you a nightmare.
Thank you. Mika, do you have anything to add to this?
No, just one point. I think that we should note when we're thinking about law and AI that AI doesn't really care necessarily only about law in this sense. We can build systems that take into consideration the business logic, corporate finance in the same system. So this kind of flowing of information and knowledge from different fields together might create something that we haven't seen before, like a really savvy business lawyer, banker combined. So we might see some consolidation of various fields of knowledge. A
sort of an expert gestalt. Okay. I've got a very mundane question. So, I mean, even today, law work has to deal with a mountain of papers. I've seen sort of juniors with these boxes at the Inns of Court, moving them around to different buildings. How electronic can the maintenance and application of law really become? Because I mean, we have some tools, semantic databases, for example, but they're not mature at this stage, is my view. Anyone care to?
So I'll give that a go. When I launched my firm, which was about 2.5 years ago, part of what inspired me to do so is I left another smaller firm where we had both what we call Iron Mountain. It's the place where you sent offsite document storage, and we had on-site storage as well. And we were a very small firm. We were 2 lawyers, but yet we had rooms and rooms of boxes and documents. And my part of why I decided to leave that firm was that I wanted to try and practice law differently. And so I had this very specific goal of saying, okay, can I go paperless? So I'm very pleased to tell you, I'm sitting in my office right now and I have a single box in my office. That single box has original signed documents, whether there are things like witness statements or awards that I've issued as an arbitrator, and it's the original that I signed. So I have a single box of paper in my office. I have a lot of books and other things, but in terms of legal paper, and I come from global law firms where you just have, rows and rows of filing cabinets, and even, in small law, as I told you, you could have the same, and I've seen that. I really did want to challenge myself to go paperless. And so far, it's been really easy. Of course, a lot of courts do have paper filing requirements. And so you just produce the copies that you must for that purpose. And, that's their problem. That's their paper, not my paper. But I've been able to eliminate paper from my office, and it has helped because am more likely to have electronic copies on hand that I could find through, which I might have turned to a hard copy document in the past just because I had it. And so since I don't have it, I've become better at marking up electronic documents and reading electronically and things like that. When I definitely was among the people who preferred to print something out, to read it, to refine it, to edit it. I don't do that anymore simply because I made the decision not to. And then I forced myself into that box. So I think it's quite possible that the problem is, other players, other stakeholders that you interact with may require paper. But I think on a personal level, we can manage and minimize that and switch to a more electronic driven process.
Thank you. Rupert, do you agree? Can we dispense with the papyrus?
Well, I mean, as I say, the elephant in the room is always economics. It can be cheaper. Not always, but can be. I think for many large cases in courts, there's a requirement now to be either completely or mainly electronic. There's also, of course, a generational thing that sort of old school barristers do like to have files that they can thumb through, but I think that will change. So I think it's all heading towards electronic.
Okay, Mika, have you looked at any of these electronic tools?
Not that much, but I know that something that I wanted to mention is regulatory avalanche that we're facing all the time on the legal side. And there's no way, I think, anybody would, contradict, would be probably lying on some level. There's no person, for example, who can handle financial services regulations currently on the level of what we have. And these are the systems that are necessary for us to comply or actually even deal with the regulatory avalanche that we're facing all the time from all directions, EU, domestic, international authorities. So I think it's a must currently.
Bhagyashree, anything to add here?
Again, I come in with a dissenting view here. So we need to look into the factor in the fact that we are all sitting in highly developed countries where we have access to technology and we have the ease of usage of technology. Now, if we were to look in jurisdictions or societies that may not have such access to technology or electronic systems of maintaining paperwork, we still do it manually. Even in India, a lot of, even in Supreme Court and the high courts, a lot of work is manual. There's very less electronic recording systems that are in use, and that's mainly because we have to look the fact that law and justice is for all segments of the society. It's for the rich and it's for the poor. The poor cannot afford it. So just because they cannot afford it, they shouldn't be, streamed out of it. And when for one, I'm a proponent of using electronic systems because save paper, save trees, right? But we also have to look into the fact where the client would have access to such a technology. And then, of course, we have the regulatory framework that mandates some amount of paperwork that needs to be filed, that needs to be retained, that needs to be recorded for future purposes. So I think it's a mixed view here. Definitely should go in for this, but can we go in for this is the bigger question, considering the fact, the ease and the adoption of such technologies across the globe.
Okay. Well, thank you very much. Okay, I'm going to bring this ship into shore with a final question. Considering the potential benefits and risks of AI in the legal system, what is the one key action you believe policymakers or legal professionals should take to prepare for the future? Rupert.
Oh, good question. I mean, I the joke answer would be get a hobby, and try and diversify. I mean, I think that yeah, I mean, generally, just try to take as broad a view as possible, and don't get stranded. But Richard, if I can make one additional point, something that I think is also very important, apart from the economics, well, as a part of the economics, and that is that there's been a huge sort of global market failure in access to law. And so one very good feature of this move to AI law is that that could be remedied. Law could be available at pretty much zero marginal cost around the planet to everyone who needs it. And just picking up that last point, even in the most underdeveloped countries, I mean, if they've got a good mobile phone network, I know they do pretty much across Africa, for example, they've got the cloud, really, you've got access to everything. So
Mika,
those features are very good.
Yeah. Thank you, Rupert. Mika, coming swiftly onto you, because I know that you believe in a level playing field, access for all. Would you like to sort of...
Yeah, fully agree with Rupert. Fully agree with Rupert here. I don't think policymakers should not overreact too easily and overregulate things. I think that's something we need. Transparency issues, that's for sure. But I fully, what Rupert said, I'm fully behind that. Access to justice, that's really important. That's an extremely positive development.
Okay. Bhagyashree, one key action you believe policymakers or legal professionals should take to prepare for the future? Not
overly regulate the innovation and technology. We are seeing, we've already, I mean, AI Act was it came into force only a couple of days ago. People who were working behind the scenes to get the products of the companies already compliant, such as my company, we already have started to see the knee-jerk reaction to how it's stifling innovation and competition. So do not overly regulate it. There needs to be a room for innovation, or else there's going to be no progress.
Okay. And last but not least, Kiran, what would you say?
So I did agree with everything that's been said. So I'll throw something different out there, which is we are in a world where more of our data and more of our information is digital. And so I think we just need to keep in mind various guardrails that have always predated these systems, including things like confidentiality and privacy law and things like that. I want to add one more random comment, which is we shouldn't underestimate technology. So you'd be surprised where really interesting ideas can come from that are technologically driven. I was recently doing some consulting in Pakistan in helping them develop ADR systems in conjunction with the courts. And I heard the smallest thing that just really opened up my eyes. The courts in Sindh province in Pakistan, so going out into more rural regions, now have all the court documents are issued with a QR code at the bottom. And you scan the QR code, and you get the whole docket. And my mind was blown. I was like, that's brilliant. I would love to scan a QR code and get access to the whole docket. And the idea is that litigants in the courts like to do that, right? It's an access to justice mechanism that if you scan the QR code of the order or the court document that's been issued, you can see everything. And that sounds revolutionary to me, but it's actually probably not that hard to implement. And I've collaborate with the teams where they're working with the IT professionals in these courts to help them with how do you build, public dockets and accessible systems. And it might be hard on the back end, but you'd be amazed how a small improvement can change the game. And for me, that particular one was eye-opening because it is not, and we used QR codes for all sorts of things. So it's not a big deal, but it was really innovative and interesting and I think added value to the legal practice and access to the legal field for others.
Great. That's very, very practical point upon which to end. Thank you very much. And I think, I mean, we're over time. We could actually carry on all day. It's been a fascinating discussion. Thank you to all our panelists, Kiran, Mika, Bhagyashree, and Rupert. You've been extremely generous with your time, and it's been incredibly insightful. And thank you all to also to our audience who's attended. This talk has been recorded and will be available online at the Institute of Science and Technology's website. Thank you very much. Goodbye.